Hello, and thank you for joining Clever's webinar on understanding security and privacy in education. We're really excited that you're here. A couple of housekeeping things before we dive in. This will be interactive, so you can submit your thoughts and questions on the right side console on your screen, and we'll make sure to answer your questions at the end. We're going to be giving you a lot of information, so we put together a list of helpful resources, including websites, books, and Clever materials for you to reference afterwards. You can find this also on the right side of your console. Have a colleague that can't make it? The session is also being recorded, and we'll make sure to send you a copy afterwards. And finally, not only is this interactive, but this is also an ongoing conversation. So be sure to join the conversation using the hashtag #CleverWebinars, as you can see on the footer. Before we get started, we'd love to learn a little bit more about you. So you can go ahead and answer the poll as it pops up on your screen. All right, awesome. There are a lot of application developers with us and folks from the app side. Welcome. About a third of you all are district folks. And we also have quite a few folks from the privacy and security industry and some fellow lawyers. So welcome. Real quick, figured we'd tell you all about us before we start. My name is Liz. I'm excited to be here with you. I spend my days working with districts and thinking about student data privacy. I get to bring in my experience as a former teacher and a licensed attorney to help Clever navigate the legal landscape of student data privacy. Joining me is Alex Smolin.
Hi, my name is Alex Smolin, and I lead security engineering for Clever. Previously, I worked at Twitter as the lead for the account security team. Liz and I are both members of Clever's Policy Guild, a group of Clever employees who work on projects to help Clever protect student data, privacy, and security.
Great. I want to give you a framework about what we'll be talking through today. First, we'll discuss why Clever. Why are we here talking to you? Second, we'll run through the complex world of federal, state, local, and industry regulations and laws. Next, it's a complicated world out there, so we'll talk through our framework on how we apply these regulations to our product and team. And last, we'll talk about how Clever, as a tool, can take some of this off your plate. And like I mentioned before, in case we don't get to everything, we will have a Q&A session at the end. So make sure to submit your questions throughout the webinar, and of course, you'll get a copy afterwards. All right, so what is Clever? And why are we the ones to talk about security and privacy in education? Well, Clever is an application management platform, and we have two sets of partners. For our district partners, we offer rostering and single sign-on for teachers and students. For our application partners, it's a way for you to securely connect your applications to both student information systems like Infinite Campus or Aries and identity providers like Active Directory or Google. Because of this position within the industry, we see trends in both applications and district side. And because of our scale, we're able to offer insights. As you can see, we have 30 million students on Clever. We're in over half of the schools in the country, and we have over 250 application partners on our platform. One last quick thing before we start. This is not legal advice and is intended to offer a broader brush perspective. We highly encourage you to speak to your own lawyer for advice for your product, your team, or district. Okay, now that we've talked about what Clever is and who we are, I'm going to pass it off to my colleague, Alex, to walk us through security and privacy framework.
Hey everyone, thanks for attending. Security and privacy are broad topics, and I'd like to start with some clarifying definitions before we dive in. Security and privacy often get lumped together in discussions about student data, And while they're related, there are some important differences. When we talk about privacy, we're talking about people having control over how their personal information is shared. When there's a privacy breach, it means some information about you was disclosed in a way that you didn't want it to be. Security, on the other hand, is rooted in the idea of antagonistic actors or attackers. Someone wants to achieve a goal, and you don't want them to achieve that goal. Security and privacy do not always go hand in hand. As an example, many schools have surveillance video cameras, which might increase student security, but decrease student privacy. One thing that ties security and privacy together is that as an education technology company, a very important motivation for doing security and privacy work is the law. Between federal law, state law, and contractual obligations, education technology companies have multiple legal requirements related to student data privacy, and it's an area where privacy and security are linked. When you hold student data, you need to prevent security breaches to preserve student privacy. If your company is like Clever, you've heard a long list of acronyms that have P's standing for privacy, like FERPA and COPPA. You've heard about dozens of state bills that protect student data, and you've been asked to sign multiple contracts that mention security and privacy. And you've probably wondered how anyone can actually keep up with all of this legal jargon. A study at Carnegie Mellon estimated that it would take 76 work days for a person to read all of the privacy policies for the websites they visit every year. As an education technology company, not only do you need to read every applicable law and contract, you also need to ensure that your company complies with these regulations and agreements. It can be a struggle. And it's all time that's spent not building features or providing support. Clever's felt this pain, and we're here to share some of the things that we've learned about how student data privacy legislation can be understood and operationalized. Liz is going to start with a discussion of the legal landscape for student data privacy, and then I'll talk about how we operate our security and privacy programs to reduce legal risk. Take it away, Liz.
Great. Okay, let's dig into the legal landscape. We're going to be talking through student data regulations and trends at all levels, from federal to local. This ends up being a fairly complicated layer cake. At the bottom, you've got federal laws. They're the floor. They represent the minimum protections that must be afforded to students. Then, as you know, states come into the picture to fill the holes left by the federal government and add additional protections. They vary widely. Gets even more complicated as local regulations and contracting comes into play. Districts and LEAs create their own contracting frameworks that ed tech apps have to comply with. And finally, we have to look at how the industry is responding and moving forward. And of course, to bring this home, increasingly districts know and care about legal requirements. In fact, a district administrator told me last week that the first decision they make in purchasing is whether the acronym has quote unquote acronym safety, which I think is great. And so what did he mean? I'm going to introduce you to some of my favorite acronyms, and we'll start with federal law. So we're going to focus on the three biggest federal laws in regards to student data privacy. This is not an exhaustive list. The oldest is FERPA, passed in 1974. Then COPPA came in 1998. Most recently, ESA was passed in 2015 and is coming into effect this year. For each of these laws, we want to think about three things. First, what does it mean? Who does it affect? And how is it enforced? So let's look at FERPA. This law established protection over student records in schools. It essentially did two main things. First, it allows parents to request review and change a child's record if it's wrong. And it requires the school to get written permission from parents before releasing that student information. So then you have to ask yourself, if you're on the application side, do you have written permission from all of your parents to have and give student information? Likely not, but that's okay, because the law allows districts to release student data to school officials with quote-unquote legitimate educational interest. And most education applications fall under this designation. FERPA is administered by the U.S. Department of Education against a district, which means a district could lose funding for a FERPA violation. Districts are responsible for complying with FERPA, As vendors, we help districts comply. However, our next law, on the other hand, COPPA, applies to vendors. So COPPA details requirements for websites that have users under the age of 13. And I want to highlight a few of the requirements that are most relevant to applications working in schools. First, you have to have a clear privacy policy. You have to protect and delete personal information, which has been come to know kind of colloquially as PII, personally identifiable information. You can't disclose information to a third party. You can't have any targeted ads for kiddos under the age of 13. It's administered by the FTC and is enforced against the vendor. This means that the FTC can fine any application who violates the law. In 2015, ESA passed to replace No Child Left Behind and reauthorize the Elementary and Secondary Education Act. This is an extremely complicated bill, and I'm only going to mention a few parts most relevant to privacy and security. In Title IIA, the law provides opportunity to use federal money to train teachers on student data privacy. This will likely increase the demand and the pressure on edtech apps to have higher privacy and security standards. Also, the law establishes 3 new categories of data reporting for foster, homeless, and military youth. This law is administered by the U.S. Department of Education. So on the enforcement side, districts could face a funding reduction if they misreport on these 3 new categories. So federal laws are showing their age. FERPA is 23 years old, and it was written at a time when student records were paper files held at a central office. Because we live in a world of technology-enabled learning, the distribution of student data, quote-unquote, files is wider, and access to those files is easier. However, there have been few changes in federal law, so states are stepping in to legislate in this world of technology and to answer the increasing demands for privacy. So we're looking at a chart compiled by our friends at the Center for Digital Education. As you can see, in 2013, the first student data privacy law was passed in Oklahoma. You can see a massive jump between 13 and 14 as this law and increasing advocacy triggered a massive jump in student data privacy awareness. And new laws were passed to fill in the gaps from federal law. The decrease between 2015 and 16 could be attributed to the passage of ESA, causing a shift towards the new federal regulations. However, privacy and security are still top of mind. As we've seen in the first 3 months of 2017, there have already been 128 new bills introduced in 34 states. So just to summarize, right, since 2013, there have been 91 new laws specifically on student data privacy in 38 different states. This creates a web of different requirements and definitions. For example, some states protect, quote-unquote, personally identifiable information. Some layer on top and also protect pupil-generated content, and others protect directory information in addition. Tracking these definitions and what they may imply for your product can take some serious work. All right, let's highlight 3 state trends that are especially applicable to vendors. So one of the top trends is data stewardship, which is what really this means is that we're determining how electronic data should be treated and protected. Essentially extending COPPA to all of K-12 and adding some additional protections as new technology comes out. This, of course, varies widely by state. For example, some prohibit advertising, some prohibit targeted advertising, others third-party advertising, and still others third-party ad networks, which actually Alex will touch on later. Interestingly, the most important piece of data stewardship is training. The most common reason for disclosure is human error, but only 18 bills of the 452 introduced so far even talk about training, and none had funds attached. Another trend is transparency. Transparency to parents and students across the district on what pieces of data are going where. The most common here is requiring applications in schools to disclose what data elements are being collected and who they're being passed to. The most extreme example right now is Connecticut, as it requires local and regional boards of education to notify parents within 5 business days each time a new contract is signed that would affect their child. To give you a sense of the velocity of change, there's actually been 17 bills introduced in Connecticut state legislature this year to change or amend that law that passed last year. Last trend I'll touch on is opt-in versus opt-out. These provisions give parents permission to opt their child out of using certain applications, or occasionally it's the opposite. They demand that parents affirmatively opt their child into using the online learning applications that would have access to the child's data. So some districts that I work with must have the ability to opt certain children out of using learning applications, and it's important to be able to do this work for the district. All right, let's add one more layer. On top of all these state laws, LEAs, charter management organizations, and districts often take further initiative to protect their students. So the web of federal and state laws, coupled with local concerns about student data privacy, lead to an increase in contracts between vendors and districts. The contracts are called various things like MOU, DSA. Sometimes you'll have to do an RFP. Sometimes they're called the scope of work. These contracts vary in quality and length. I think the longest one Clever has ever signed is 110 pages, and the shortest was 1 bullet point. These contracts come with high transaction costs, often ambiguous terms, and are difficult to track and maintain. For example, Clever recently signed an MOU with a district that says, quote unquote, the termination of our account must happen within 5 business days. Of course, it begs the question, what does termination mean here? Does it mean to stop receiving student data, to delete all student accounts? Does it also imply deleting all the backups? It's difficult to know, and as a young industry, some of these terms aren't well defined and have no common definition. Because of this confusion and high transaction costs, there's actually a movement towards norming around language and increasing transparency. And it's an exciting time to be here and watch the industry grow up. One of the outcomes is the birth of common contract language. This movement is spearheaded by the Student Data Privacy Consortium, a group of district administrators who analyzed all the state laws and found that actually 80% of the requirements are the same state to state. 20% are different, which means that most of a contract can be the same and used across all states. Some Massachusetts districts have started publishing their DSAs online, and a California group created a common contract for all of California with input from many vendors and districts. They successfully created a middle-of-the-road contract that creates norms around timeframe and establishes common definitions for terms. Clever is a proud signatory of this contract, and you can find it in our list of resources. So while contracting is important to keep an eye on, there's one last bucket that we'll touch on quickly: industry trends. And of course, there's 3 big industry trends worth noting today. The first is that EdTech is starting to self-regulate through interest groups, like the Cloud Security Alliance. Second, the industry is coalescing around certain minimum requirements for student data privacy. For example, the Future of Privacy Forum Student Privacy Pledge, which is an independent document signed by over 300 EdTech vendors that commit vendors to 12 provisions, such as not selling student data or not building student profiles for their own purposes. And third, the industry is also seeing third-party auditors spring up, such as iKeepSafe, that will audit a company for security and privacy and recommend changes, or Common Sense Media, that's auditing the privacy policy and practices for all EdTech applications and assigning a rating. These practices will likely grow and change as the industry changes. Okay, phew, I hope you're still with me. That was all very theoretical, so let's make this real by looking at a case study. So we're going to talk about California. Clever is in about 70% of California districts, so it's a state we know pretty well. And I'm going to walk you through an example about what it would be like to be a new application trying to connect with schools in California. All right, so let's all imagine we're a new elementary school math application, MathFax, and we want to work in California. So what would the legal layer cake look like? First, you would have to consider our 3 federal laws, FERPA, COPPA, and ESA. Do you have a way for parents to change their students' information within your system? Do you have a mechanism for deleting student data as required under COPPA? Can you fulfill a request to report on foster youth if the district asks? Next, MathFax would have to layer on California state laws. California became the trendsetter in student data privacy after passing SOPIPA, a prohibitive law that limits third-party advertising, among other things. In fact, SOPIPA made such a splash that copycat bills were introduced 44 times, and over 10 have made it into law in different states. In addition to SOPIPA, the MathFax crew needs to think about the requirements to contract laid out in AB 1584, and to be sure to follow the very specific breach notification requirements found in California Civil Code. Of course, these are in a different section than education, in case you try to find them. All right, so now as an application, we could work in the state of California, but we have to, of course, contract with specific districts. So let's say MathFax then needs to apply for an RFP in 2 different districts, committing to additional security requirements, or assigns multiple DSAs in other districts that require different breach notifications. One district perhaps requires notification within 3 hours, another within 5 days, yet another within 60 days. And the California state law requires breach notification be made in the quote-unquote most expedient time possible and without unreasonable delay. So our MathFax team would have to determine the very best way to comply with these competing requirements. Last, but not least, MathFax would have to check in on industry trends. A district may ask if they've signed the Student Privacy Pledge. Another will ask if they can sign the California Common Contract created by SEPA. It's important for the app to be fluid in these trends. And of course, once MathFax gets a system into place, they will have to monitor these trends and track for changes that emerge after each legislative session. So how does this team keep up to date? They'll probably have to review and audit new legislation, follow new decisions pending from AGs and FTC, guidance from the US Department of Ed. They'll read and share articles relating to local and industry trends, and review and update the privacy policy to ensure new product features are compliant. This takes a lot of work and vigilance to understand and apply the legal requirements. But to give you a better sense about how Clever does this in all 50 states, I'm going to hand it over to Alex Smolin to walk you through security and privacy by design at Clever.
Thanks, Liz. Keeping up with the changing legal landscape of student data privacy is a challenge, especially for companies without large teams of lawyers and compliance staff. At Clever, we try to minimize both our legal risk and the effort that we need to spend to stay compliant. So I want to start with a story that began a couple of months ago. We received a notification from our in-house counsel with some news about privacy law. The New York Attorney General had just announced settlements with companies including Viacom, Mattel, and Hasbro, with penalties of nearly $1 million. These companies had been found embedding third-party advertising trackers in their websites. While the companies argued that the websites were directed towards parents, under COPPA, website operators must treat mixed audience pages as child-directed. For those not familiar with how third-party advertising and online behavioral advertising work, it's typically implemented with a single line of code on your website that calls out to a third-party advertising network, which collects usage data, aggregates it across sites, and then resells it. At Clever, data security and privacy really is a core part of our mission. We think about it for every change we make and new feature we introduce. For that reason, we're very careful about the third-party scripts we include on our website. Our lawyer noticed that one of our scripts on our front page marketing website, clever.com, was labeled as an advertising tracker by a popular privacy-enhancing browser plugin. She suggested that it put us at risk of being liable under COPPA, and if we wanted to keep it, we would need to modify our privacy policy. We had previously determined that this script was acceptable by our policies, but based on the update, we investigated whether it actually was an advertising tracker, and based on our analysis, we determined it was being mislabeled. It was still, as we had previously thought, a first-party analytics tracker. It gathered statistics about visitors to our sites, what links they clicked on, and so on, so that we could improve how our site works and better serve our customers. That said, to be cautious, we removed this script from our Clever.com website, which many children visit when asked to log into Clever. And we didn't stop there. We wrote out a policy on our internal knowledge sharing portal about third-party scripts, where they are allowed, and the review process for adding them. Additionally, we started to roll out content security policy, a technology that automatically blocks external scripts from loading unless they are specified by the HTTP response header. The outcome is that we have a clear understanding about how we comply with COPPA's terms around behavioral advertising, and we have automated enforcement. This is the type of approach that we believe scales when dealing with legal risks related to security and privacy, and I'd like to outline how we think about it. The first thing we do is we read laws to determine the technical and procedural controls they reference. Once we understand the required safeguards, we can then define or reshape our policies to communicate how the controls affect the people in our organization. Once we've established the concrete effects of the law on Clever, we can then start building automation to lower the cost and effort of following the policies and maintaining compliance. When we analyze a new piece of legal language, whether it's a new state law or a data use agreement from a district, we first identify the objective or prescriptive elements of legal language related to student data privacy in it. This is really about reading the fine print, and we rely on our lawyers to help us highlight sections that are relevant for us. Sometimes terms are vague or subjective. For instance, California State Bill 1177 states that operators shall implement and maintain reasonable security procedures and practices. This doesn't really tell us much, but it is important for us to have a working and shared understanding of what industry standard means to us. Sometimes elements of a law aren't always applicable. We've received data use agreements that talk about HIPAA, even though we don't receive medical information, or talk about how server rooms should be locked, even though we're hosted entirely in the cloud. And finally, some elements can be contradictory. There's a common section I've seen in a large number of DSAs from districts that mandates encrypting user passwords, which isn't consistent with security best practices for the industry. In these cases, we try to understand the intention behind the statement, since the language may have been written decades ago and security technology changes on a much faster scale. When we have identified the aspects of a new law or contract that apply to student data privacy and security, we attempt to map them to existing controls. So if a new law mandates encrypting student personally identifiable information, we map it to our existing data encryption controls. The goal of mapping laws to these controls is to identify gaps in our policies. As Liz mentioned, we've seen examples of districts requiring very different notification timelines for data breaches or for data retention. In some cases, the law in question is more lax than our existing controls. In other cases, our controls are less strict and we may not have a control for the legal issue in question. In that case, we create a plan for addressing the gaps. In some cases, that can be a difficult and expensive process. For instance, our project to encrypt all data at rest took several months of effort. It's important to be able to directly map the legal risk, though, to the engineering project so that the priority is clear. Finally, while we're creating controls and communicating policies, and those are important first steps, they don't necessarily scale. Perfect policy does not lead to perfect compliance, and policies by themselves are still just words on paper. People take the path of least resistance, and sometimes security and privacy isn't the primary objective for an employee. So having a documented process with logs for how policies are audited is a good start, but automation is even better. For example, how are new employees offboarded and onboarded? How are new machines provisioned and deprovisioned? How is code reviewed for potential security issues? These are all areas to build automation around. In the example I mentioned earlier, our use of content security policy means we need to spend less time checking for the use of third-party scripts because our servers do it for us. An important step to building this automation is to ensure that there's a role within the engineering organization that has this responsibility. It's fascinating to see how these concerns have become a formal part of many engineering programs. Security engineering as a common job title is relatively recent. Privacy engineering is even newer. I literally heard the term compliance engineering for the first time last year. Because these laws affect the organization as a whole, and because anyone can make a mistake that could end up having serious legal ramifications, security and privacy of student data is everyone's job, But that said, someone should be responsible, and having engineering as a key stakeholder is important because automation is investment in the process. At Clever, we've spent a lot of time and effort understanding the security and privacy requirements stemming from the law, and we use that as a baseline for our security privacy programs. It's important for our business because we tackle some very difficult security and privacy challenges, including transferring student data and authenticating students and teachers. Now I'd like to hand it off to Liz, who's going to talk a little bit more about how Clever fits into this picture.
Great. So before we open it up for questions, we're going to talk really quick about how Clever fits in to this world, specifically on the application for application developers and kind of what peace of mind we offer districts. So if you're thinking about maintaining security and privacy of data and transfer and authentication, you have essentially two options. You can build it yourself, which is hard, but possible, or you can use a service like Clever, which means less for you to think about when dealing with these sensitive areas. The most difficult areas of compliance are data transfer and authentication, which Clever can take off your plate. So as an application, you probably already know that the area of data transfer is really thorny. You're taking data from a bunch of different types of systems and bringing it in-house. There are a lot of things that can go wrong. Clever can help because we get to think about this for a living. We have the latest security protocols, vetted implementations to ensure data transfers are smooth, and data encrypted in transit and also at rest as required by law. Another area that is tricky is authentication. And with Clever, you can be sure that every single user is authenticated in compliance with the regulatory structures. And this also takes work off your plate because there's less security critical authentication code that you would have to build and maintain as an application. Whether you decide to use Clever to take some of this off your plate or not, I do want to point out that we love to share our hard-earned knowledge. You can find our award-winning privacy policy in GitHub. You can look through our security white paper and blogs to get an idea about how we protect our system. And make sure you download the PDF provided at this webinar because it contains a lot of great resources that we actually use really frequently to build our policies and create the best product. And, we wish we could say that if you use Clever, we can ensure that you are totally compliant with privacy and security regulations and laws. Unfortunately, that is just not true. Hopefully this webinar helps you understand where you're at and what you need to do, and of course, how Clever can help. But there is no silver bullet. Running an effective security and privacy program takes time and effort. All right, so make sure to check out our list of resources to help, and we'll open it up for questions.
Okay, I'm going to go ahead and take the first question about whether Clever uses third-party auditors for privacy, and if so, do we find this helpful when talking with schools and districts? Clever does get regular security audits from external firms, and we found that this fills an important gap in sort of our overall security and privacy program. The thing about external audits is that they do give you a really good outside perspective. So, a lot of times, because security is adversarial in nature, it's important to get some fresh thinking about how your systems work and how they work together. One of the problems with external security audits, though, is that because they can't be continuous, they only represent a snapshot of your security posture at a given time. And so because Clever is constantly releasing new features and updates, we can't rely on our security audit as a sole control for guaranteeing our security. Furthermore, security audits happen after code is already shipped, and we think about security and privacy much sooner than that. One thing I would recommend for getting third-party security audits is to regularly rotate the auditors that you use. Again, as I mentioned, it's important to get fresh thinking, and by bringing in new people, you can get new sort of attack paths tried out, and so that can be useful. Another way to improve the continuous nature of a third-party audit is to look into hosting a bug bounty program, which have become popular over the years. A bug bounty program allows you to reward external researchers for finding security issues in your services, and because that happens continuously, it can increase increase how quickly you are able to find these issues.
Great. I'm going to answer a question about the future of federal legislation, as in what's happening there. So there have been many calls for FERPA, our 1974 law, to be updated and amended. Compliance with FERPA actually confuses a lot of people. If you are one of them, that's okay. You can actually go to the Procurement Technical Assistance Center, known as PTAC, in the U.S. Department of Education, and they've got a lot of guidance there with good resources. PTAC last year got 12,000 calls about FERPA. So you're not alone if you're having a hard time figuring out how to apply this law. In terms of future federal trends, there were 8 bills introduced to update FERPA in the 2015 Congress, and 2 will likely be introduced in the next 2 years. There was a significant FERPA rewrite from the House. However, because of budget cuts, it doesn't really seem like it's likely that any of these will get through. So I wouldn't expect a change. And in fact, I would just keep tracking. I would suggest that we all keep tracking the state legal trends rather than looking towards the federal, because I think that is where the action will happen.
Great. I'm going to answer a question. Someone asks, you mentioned you're hosted in the cloud. What is the legal framework that applies to the cloud and encryption at rest? So I think, for us, many laws don't necessarily they predate the prevalence of cloud computing, and so we have to figure out how they apply in this new architectural pattern. One of the things that's really important for us is to understand the shared responsibility model that comes with cloud computing, because when you're hosted in the cloud, there are certain security and privacy issues that are outside of your responsibility. And you can rely on the auditing and compliance reports from your cloud provider as sort of evidence of protection against those threats. But there are other things that that remain your responsibility. So the security of the code for your application, or the security of the configuration of your virtual networks. And understanding the security model for the cloud provider, I think, is really the first step. There are not many legal requirements I've seen that have very direct guidance when setting up a cloud application, but indirectly, there are a number of recommendations about using, for instance, the industry standard security practices. That, I think, sort of dictates how you should be configuring and running your cloud infrastructure. So it's definitely one of those areas where the law and technology are not moving at the same pace. And so it can be really challenging, and especially with a topic like encryption, where in many cases, if you're using cloud computing, the cloud infrastructure holds both the encrypted data and the key. And so that can be difficult to ensure that access control to the key and the encrypted data are separate. And we've actually found that we're able to use encryption in the cloud very effectively to protect data with different levels of classification and to add additional auditing over who gets to access that data and how that data is accessed. So we've actually found it very helpful. Hopefully that answers the question.
Great. I'm going to pick up. So there's a question about privacy policy audits like iKeepSafe and similar offerings. I think these are great, especially if you are if you're kind of bootstrapping, you don't have your own in-house counsel, you're not keeping someone on retainer to kind of do these audits for you. I think iKeepSafe can do a great job, and similar offerings can make sure that you are up to date. They also indicate to the rest of the world in terms of like perception that you are taking this seriously and making changes. And I think that keeping up with this is difficult. And I think that like one of the other questions asked is if there's a newsletter you can subscribe to get a notification when privacy law is updated or adopted. There's a bunch of them. One that I follow really closely is Amelia Vance's newsletter from the Future of Privacy Forum. It goes out, you can track her work at FPF, and it goes out once a month, and it's got a lot of really good information on upcoming laws and kind of trends and what's happening both on the district and vendor side. And one of the great things about having these resources, and you, of course, check the resource sheet that we've provided to see what we do reference, is that there are a lot of people who are thinking about this, and you can pull from these newsletters and use these third-party auditors to kind of keep yourself on track and on top of it, either from the district side or the vendor side. If you are a district in Connecticut or Colorado that is particularly required to publish the data elements that are being shared and often privacy policies as well, I would recommend looking at Common Sense Media's work. They audited everyone's privacy policies and can give you a sense of where the application stands. If you're a vendor, I would go check that, and you can see where you might need to address some other pieces within the legal framework. So again, these are in the resource PDF, which you can find. So hopefully that is useful. But yeah, we find that that there are a lot of resources. They're super, super useful to keep track of.
Okay, there's a question asking if we have a list of third-party trackers that are unsafe or a list of first-party trackers that are safe. And I wish that the answer was yes, and I could point you to some website. Unfortunately, as far as I'm aware, no such list exists. The privacy enhancing browser plugin that our lawyer had used to identify the potentially objectionable script was called Ghostery. There are several others that will block third-party advertising networks, and you can look in the logs of these tools and see if they block traffic. But as we found, these lists can be inaccurate. And I think that there's other challenges when you need to distinguish between whether a third-party script is acceptable or unacceptable. For instance, we use Google Analytics, which is a very widely used first-party analytics tracker. But what we learned is that when you configure Google Analytics with certain values, it will actually load some script from DoubleClick, which is a third-party advertising network. And we found this very surprising, that depending on how you had configured this script, it may actually load something that would be against our policies. So what we've had to do is actually go in, and if we do want to implement a new tool that requires loading third-party script, we need to go and audit their privacy policy and understand sort of the overall security and privacy footprint of the vendor before we can include them on our website. And that's how we make those determinations.
All right, I'm seeing some district side questions on clarifying when schools need to get parent permission, and then ways to help kind of connect parents and tutors kind of train them on when and how to treat student data. I want to point out two things here. So Common Sense Media is coming out with a bunch of tutorials that are like small, I think, videos that are educational about student data privacy that will be free. If you are a district, I recommend keeping your eye out on these like free training resources that some of these third-party neutral and advocacy organizations are starting to create. I would use the ESA money that is on the table, provided the budget gets through this session, to train teachers and to create resources for parents. For in terms of getting parent permission, so this is probably one of those 12,000 calls that goes to PTAC. So I would recommend checking out the PTAC guidance. They have a lot of information about how and when to secure parent permission for sending pieces of student data to applications. I would remind you that different applications need different amounts of data. So some just collect first name. Some need, if they're an intervention math app, might need more information, like the section the student is in, the grade level. They might keep a historic profile so that they can, continue to help adjust to the student's level as they increase. So it really depends which application you're working with, what data elements you're sending. And so keeping track of that is important. And I would say that in order to kind of educate your parents and your stakeholders around this, there are some really great tools that are coming out. So yeah, Common Sense Media would be the biggest one I would suggest you check out. Oh, yes, of course. Jim, thank you. Jim Siegel, who's one of our pioneers in this, works in Fairfax and is a great privacy expert. He is pointing out that COSN has also been producing privacy materials that are really wonderful, and they are available. So if you go to COSN, COSN, if you're vendor side or district side, you can go check these out. And they offer a lot of guidance and help on training and kind of helping districts think about this. So COSN has been doing a great job with this as well.
Okay, I think I'll try to answer two questions at once. One is whether we audit websites, and another is what are the areas that Clever offers no protection. So I wanted to clarify how Clever fits into the sort of security and privacy picture for student data. Clever is not able to verify the security and privacy of every educational technology app on the market, and that responsibility is based on the relationship between the district and the educational technology app. So what Clever does verify is that the data is transferred to the app, and if single sign-on is enabled, that the authentication process conforms to industry standard security and privacy best practices.
All right. So another question we have, is there any known cases of ed tech companies in the past few years who have been fined or damaged for breaking federal, state, local industry laws or standards? So this kind of depends how you want to think about damage. I think there is a large perception risk here. Actually, just to borrow Jim's framework. So privacy and security is really about risk. There are like compliance risk, as in legal risks, like getting fined. There's actual security and privacy risk, and then there's the perception risks, and all of those can kind of damage a vendor or a district. So there have been state AGs, for example, in New York, who have started looking in and applying COPPA and fining ed tech apps under COPPA, or educational websites, I guess, under COPPA. And we've certainly seen districts both in Seattle and in Chicago that, because of data breach, have had a big perception problem. Both of those were about exposing special education data inadvertently to a very, very small number of people. So Yes, yes, I guess is the answer to that question. I think it's something to keep an eye out on. We haven't seen massive fines like FTC has given to like Mattel in the past. Those have been hundreds of thousands of dollars of fines, as Alex mentioned earlier. But I think it's something that could be coming down. So something to keep an eye on.
Yeah, there's a couple other instances I think that come to mind for me. So one is that the FTC has also pointed at Google and their use of basically tracking behavior within their products that are targeted at students. Another example is there is a student data system that was configured to send the wrong data to the wrong district and had to then provide identity protection for all of the students in that district. So, that can be an example of where if there is a data breach and you're required to provide identity theft protection for those affected, that can have a financial outcome.
Okay. So we got yet another question about recommending good resources for international privacy regulations and best practices. This is a great question. Did want to flag that the EU has a new set of privacy regs come into effect in 2018. If you are an app working internationally, I would definitely keep an eye on these EU regulations. They will change your product probably. So yeah, and so that's a great question. One last thing we want to kind of flag here is that Clever is essentially a transport layer. So we are moving data in the most secure way and authenticating students in the most secure way. The data that districts send to Clever gets sent to the applications that they want it to get sent to. So if they are rostering MathFacts, my like fake application example from earlier, MathFacts does end up with data. So they do need to make sure that they have some sort of agreement with the district because they will have that data within their own system, which means that vendor needs to be compliant in terms of deleting data and protecting data and having best practices around it. So that is kind of how Clever fits into this. Okay, so I think we're going to wrap it up here, and we wanted to say thank you so much. We've got some tough questions, which we will go ahead and answer on the one-on-one basis. If you've got anything else for us, please type it in now. And we want to say thank you for joining us and being active and interested in privacy and security. You will be receiving a copy of this webinar, so you can make sure to share it with your colleagues. And of course, we have that PDF resource on the side for you. And remember, this webinar is really about risk. As Jim says, it is about compliance risk, actual security and privacy risk, and perception risk. So we hope that the content has been helpful. But we encourage you to speak to your own lawyers about this topic, whether you're a district or on the vendor side. So thank you so much, and we wish you a very secure and safe 2017. Thanks.